In a medical malpractice case in New York, can the attorney who represents the doctor whom you have sued in a medical malpractice case demand and force you to appear for a pretrial question and answer session known as a deposition? And can you refuse to appear and answer those questions? You want to know the answer? Come join me on a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you believe that your doctor was careless and caused you significant harm and injury. And now you go to an attorney who evaluates your case and determines that yes, you do have a valid case. He has had your case reviewed by a medical expert who determined that yes, your doctor was careless, that he violated the basic standards of medical care, and as a result of that, you suffered significant harm and injury. Now your attorney tells you that because he has obtained confirmation by a qualified medical expert that you have a valid basis for a case, he's going to go ahead and get your case started. Now you go ahead and get the case started. A few months down the road, your attorney calls you and says, hey, listen, I just want to let you know you're going to have to appear for a pretrial question and answer session known as a deposition. And you turn to him and say, what are you talking about? You didn't tell me anything about that. I'm not answering any questions by the opposing attorney. That's not happening. Number one, can you do that? The answer in New York is no, you can't. If you have gone ahead and started a lawsuit on your behalf in a civil lawsuit involving claims where you are trying to obtain money as a form of compensation for all the harms and losses and damages caused by a careless doctor, you will have to answer questions by the attorney who represents the doctor whom you have sued in a process called the deposition. Lawyers also call it an examination before trial. It's really a question and answer session that typically in pre-COVID times would take place in your attorney's office. Now during COVID times, this will usually take place on a Zoom video call. Your attorney will be on the call, you will be on the call, the defense lawyers will be on the call, and importantly, there will be a court stenographer on the call as well to record all of the questions you are asked and all of the answers that you give. Now, you are shocked because this is the first time you hear that you ever have to appear for a deposition, that you ever have to answer questions by the defense attorney. Had you known this information before you started your lawsuit, you would have seriously questioned whether or not to start the case, you tell your attorney. And now this is shocking to you. You don't want to have to answer questions. You've already gone through this indignity, this problem that you've had all because of this doctor's carelessness. You've spent a great deal of time explaining to your attorney exactly what happened in detail. There should be no reason in your mind why you should now be asked questions about all the details and all the events that happened to you. It just shouldn't happen, you believe. Your attorney says that's not how it works. That's not how any of it works in New York. The way it works is that when you go ahead and claim that the doctor was careless and caused you harm and injury, now your medical conditions become an open book. You now become an open book, which means the defense will be entitled and permitted and legally entitled to ask you questions. They are legally entitled to ask you hundreds, if not thousands of questions that will take many, many hours, if not the entire day, to ask you questions. And you're thinking, wait a second, this is so straightforward, this is so simple. How could they possibly be asking me questions for hours and hours, a whole day? That's ridiculous. They should know exactly what happened. Here's exactly what happens and why it takes so long for them to ask you questions. When you go to an attorney to determine if you have a valid case, your lawyer has to do a detailed, thorough investigation to confirm that yes, you do have a valid case. And he does that by obtaining all of your medical records. And he does that by reviewing all of your medical records once he obtains them. And he does that by also having your medical records reviewed by a qualified, board-certified medical expert. Now, your attorney has gone ahead and spent all that time and effort and energy to evaluate and investigate your case and confirm that you do in fact have a valid case. When you start your lawsuit against your careless doctor and the various hospitals or other physicians that you believe caused you harm and injury, the defense is behind the eight ball. What does that mean? It means they don't have the same information that you know. They don't have the same information that your attorney already knows. They don't have the information that your expert already knows. So now they are behind the eight ball. So what we have to do is we now have to give them all of the information that we have. We have to give them copies of all of your medical records. We have to give them permission slips to get all of your medical records, so now they can do their own investigation to hopefully confirm everything that we are able to confirm. That's the goal. And now, once the attorneys for the doctors and the hospitals have obtained the medical records and they've obtained expert witness reviews to determine the validity or to confirm whether or not you have a valid basis for a case, you may be asking, why do they need to question me if they have all the same medical records that you, my attorney, has and that my expert has? The reality is that you become an open book. They are entitled to verify and to confirm for themselves exactly what's contained in your records. They only have a two-dimensional picture of you and what actually is being claimed in this case, which means that your attorney has prepared a set of records called a bill of particulars that details and itemizes exactly what your claims are in this particular case. These documents itemize and allege that the doctor was careless and explain in exquisite detail how the doctor was careless and what he should have done and what he didn't do, and importantly, what injuries you suffered as a result of this wrongdoing. We have the documents, we have the medical records, we have our expert review, but we want to hear from the injured patient himself exactly what happened. We want to hear in his own words exactly what problems he had. We want to hear in his own words what complaints he made to the doctor and what he remembers happening and what conversations he recalls between himself and the doctors. We're entitled to know that, and you know what? They are. They are entitled to learn that information. And the only way they're going to learn that information is not from their own clients, because there's information that you have that I'm sure their clients don't have. So they are entitled to ask you questions about what you did, why you did it, and what you remember about it. The moment you turn around and say, hey, the doctor who treated me was careless and he violated the basic standards of medical care, causing me harm and injury. When you say that, now the defense, the attorney who represents the doctors whom you have sued, will now get a chance to verify that information from you, to learn from you in your own words exactly what you believe was done wrong, exactly what you believe occurred, and importantly, to learn from you exactly what problems you have today as a result of this wrongdoing. They are going to want to know what injuries or limitations or disabilities you currently have, all because this doctor was careless. And you are in the best position to tell them that, because they can read those records all they want. They're going to see what you complained of to the various treating doctors who are trying to get you better. But that's only a two-dimensional picture. By talking to you in person or on a Zoom video call, they now get to ask you and have you explain how those injuries have affected your life. How have they changed your life? What are the things that you are no longer able to do that you were able to do before? What type of things do you do now with limitations or with disabilities? What pain do you have because of the injuries that you suffered? What type of medical care and treatment are you going to need into the future in order to address and to try and fix the problems that you have? These are all questions that the defense attorneys are going to ask you, and they are entitled to and should be asking you those questions. Why are they permitted? Why are they allowed to ask all these questions? It's because you are now claiming that you suffered these terrible injuries as a result of their client's carelessness. And because of that, you now become an open book. And they can probe into your medical history. They can probe into your background, into your history. And you know what? There may be things in there that you don't like. Maybe things in there that, you know what, just are not pretty. And you don't want to share with them. But the fact is, you have to. Because you have chosen to go ahead and put your medical condition in issue, the defense is fully entitled within their right to ask you all these questions. Now, to the second part of the question that I asked in the title of this video, what happens if you choose not to attend this deposition, to answer the questions put forth by these attorneys? Can you do that? The answer is no, you can't do that. If you refuse to answer these questions, which the defense is legally entitled to ask, what they will do is they will go into court and they will say, Judge, Mr. Oginski's client is refusing to appear for a deposition. He's refusing to answer our questions. And we have asked many, many times, and the response always is, he's not showing up. You can schedule it, he's not coming. In that instance, the judge will likely issue an order precluding you from offering any evidence in your particular case. And you're thinking, what? What the heck does that mean? I'll tell you what it means. It means you're screwed. It means you won't be able to put in any evidence to support your case to show that your doctor was careless, to show that you suffered significant harm and injury because of this doctor's carelessness. Why? All because you have chosen not to appear for a question and answer session known as a deposition. When you bring a lawsuit, you are now required to answer those questions, which means you have to appear for your deposition and you have to answer the defense attorney's questions. If you fail to do that, they will go into court, ask the court for an order preventing you from being able to put in any proof in your particular case. And if that's what happens, now you get an order saying you are now precluded or prevented from putting in any proof about your case. There's no way you can ever get to trial. Your case will be dismissed before you ever try and get anywhere near there. Why? Because without you being able to put in any evidence and proof about the problems that you had and the reasons and the injuries, guess what? You're not going anywhere, and you will have destroyed your own case. And I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.